Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Be ready for the dictation at high speed. Ready? Start. A batch of 9 petitions is being decided by a common judgment as the counsel for the respective parties agree that the issue involved in the present batch of petitions relates to compensation for the same transmission line and can be decided together. Stop. The challenge is to the award dated 28/2/2017 passed by the additional district judge Sonipat. Stop. The landowners have assailed the judgment and decree on the ground that the same is inadequate, while the transmission licensee has assailed the awarded amount to be high. Stop. For the facility of reference, the facts are being extracted from CWP-21878 of 2017 titled as Vinod and Others versus Kalpatru Power Transmission Limited and others. Stop. Briefly summarized, the facts of the present case are that the petitioner number 1 and 2 are owners in possession of 3 by 5 share out of total land measuring 55 canal 7 marla comprising in Kevat number 6, whereas petitioners number 3 to 6 are the legal representatives of deceased Tara Chand and are owners in possession of agricultural land measuring 98 canal 4 marla comprising in Kevat number 69/60 and Khata number 101 situated in the revenue estate of village Rai Tehsil and District Sonipat. Stop. The details of the above mentioned land is duly given in paragraph number 3 of the petition. Stop. Both above mentioned chunks of land are situated in the vicinity of the border of national capital and fall within the national capital region. Stop. It is thus alleged that the land in question has a great market value owing to its potential and that the said valuation has diminished considerably on account of installation of electric poles and the 400 kilowatt high tension wires. Stop. The petitioners claim to have received notices in the year 2011 regarding installation of electric poles and erecting 400 kilowatt high tension wire in the land of the petitioners. Stop. It is averred that laying of such transmission line has affected the land measuring 8,000 square yards belonging to the petitioners number 1 and 2, whereas land measuring 6,747 square yards pertaining to petitioners number 3 to 6 was also affected. Stop. It has been averred that owing to the immense potential of the said land and the same being situated near the national capital, the market value of the land is approximately rupees 5 crores per acre. Stop. The respondents, however, awarded a very meager compensation of rupees 80,000 to petitioners number 1 and 2 and a sum of rupees 98,000 to petitioners number 3 to 6 as compensation towards the crop damage. Stop. A legal notice was served by the petitioners upon the respondent-authorities and thereafter a petition under section 16 within bracket 3 of the Indian Telegraph Act 1885 was preferred before the additional district judge Sonipat and compensation to the tune of rupees 10,000 per square yard was claimed by the petitioners qua their respective affected areas. Stop stanza. Pursuant to the notice issued by the additional district judge, respondent number 1 appeared and filed written statement, thereby raising preliminary objections regarding maintainability, locus standi, cause of action, suppression of material facts, etc. Stop. On merits, it has been asserted that the answering respondent had installed towers only as per the sanctioned route map which was provided by the government. Stop. The answering respondent had not acquired any land, rather, the land in question is fully usable for agriculture even after installation of the said towers in the fields of the petitioner's stop. It was further asserted that as per the provisions of Indian Telegraph Act, 1885, the petitioners are only entitled for compensation for the crops only. Stop. It has been submitted that notices were issued to the petitioners regarding installation of the towers of the electricity line, and for that purpose the answering respondent distributed the compensation for damages to the crops, and an amount of rupees 90,000 has also been accepted by the petitioners. Stop. It was denied that the answering respondent did not adopt proper procedure, and also denied that the market value of the land is rupees 5 crores per acre. Stop. Denying all other material averments, dismissal of the suit has been prayed for. Stop stanza. Respondent number 2 filed his separate written statement, thereby raising preliminary objections qua maintainability, cause of action, locus standi, estoppel, affixation of proper court fee, etc. Stop. On merits, it has been asserted that the line erected by the respondents is very high, and during installation no crop was affected in the fields of the petitioners. Rather, the answering respondent has paid the compensation for damages to the crops at the time of installation of the said towers. Stop. It is further asserted that land of the petitioners was not acquired, and the wires of line pass at a high distance from the ground, and the same being an agricultural land, their crops will in no case be damaged. Stop. That there can be no obstruction in harvesting of the crop merely by erecting the electric poles and transmission lines. Stop. Denying all other material averments, dismissal of the suit had also been prayed for. Stop. The respondent number 3 adopted the written statement already filed on behalf of respondent number 1 and 2. Stop. After considering the respective contentions raised by the parties and the objections filed, the following issues were framed by the additional district judge Sonipat. Stop. In order to prove his case, the petitioner examined Jai Ram Patwari as PW1, Kuldeep Clerk as PW2, Pavan Kumar as PW3, Hawa Singh Naib Sadar Kanungo as PW4, Deepak Tyagi Patwari as PW5, apart from relying upon some documentary evidence. Stop. Stanza. On the other hand, the respondents have examined Vikas Malik SE as RW1, besides relying upon some documentary evidence. Stop. Stanza. Upon consideration of the evidence adduced by respective parties, the additional district judge Sonipat recorded the following findings in respect to issues number 1 and 2. Stop. Stanza. It is not in dispute that the respondents had installed towers and high tension wires on the land of the petitioners, and that they have not paid any single paisa towards land covered under the poles of the towers or the value of such lands, except paying some compensation to the crops, etc. at the time of erecting towers and high tension wires. Stop. It is an unfortunate case where the lands of the farmers were utilized by the respondents to erect towers and high tension wires, and the reasonable and fair compensation has not been paid to the poor farmers. Stop. High tension wires were fixed on the land of the petitioners. Stop. Forever the value of the lands of the petitioners would be diminished, thereby the right to life, which is guaranteed by Article 21 of the Constitution of India, includes right to livelihood, would be affected, since they would be deprived of their livelihood in view of the erection of towers and high tension wires over the lands of the petitioners, and without paying any compensation for the land covered under the poles of towers or diminishing value of the lands stop the sweep of the right to life conferred by article 21 of the constitution of india to the petitioners is wide and far reaching stop